conference. Ladies and gentlemen, in facing globalization, which is increasingly entering life in society, nation, and state, if we see and read Anthony Giddens, thinks of the third way as the third choice between socialization and capitalization, or between state intervention and free market. At the end of 20th century, we know the world is characterized by manufacture and uncertainty, a period filled with uncertainty. The situation isn't caused by nature, but by humans themselves, thanks to the technological they created. Globalization encourages rapid social change. However, on the other hand, excessive and unwise use of technology triggers various problems. Ladies and gentlemen, I hope through progressive law, it's expected that sustainable development goals can be achieved. Once more, thank you for all speakers, Prof. Lorenzo, Prof. Teknan, Prof. Monteiro, and Prof. Dina. Prof. Dina, thank you very much for your join and coming. Once more, thank you very much for all participants and speaker. And please forgive me if I missed it. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
All right, thank you, Prof. Igusti Ayu, for the warm welcoming speech for all of us. And now entering to the next session, ladies and gentlemen, now we come to the main agenda, the presentation from the speakers and discussion session. This session will be led by our moderator today, Hannah Gracia. First of all, allow me to introduce our moderator today. Hannah Gracia is a third-year student in the Faculty of Law, Universitas 11 Maret, and she has worked and several organization experience. Hannah was an intern at Council for the Prosecution Office, Karanganyar District in January 2022, and Hannah is also active in student organizations such as ISAC in UNS and was the project officer in some international events in the university. So, ladies and gentlemen, please join me to welcome Hannah Gracia. And Hannah, the time is yours.
All right, thank you, Adinda. Good morning, everyone. Good afternoon, everyone, and good morning for the speaker. Honorable the Dean of Faculty of Law, Universitas 11 Maret, Surakarta, Profesor Dr. Igusti Ayu Ketut Rahmi Handayani, SHMM, all of our speaker and participant. Ladies and gentlemen, I'm Hannah Gracia Birliana. It gives me such a great pleasure to be the moderator for the second International Conference on Environmental and Energy Policy, or known as ICEP 2022. The theme of the second ICEP is the technological challenges in achieving sustainable development goals on water, environment, energy, information system, and future impact. The scope of the field of the participant comes from various fields, including energy, environment, epidemiology, information system, and relevant area that contribute to industrial revolution. Ladies and gentlemen, first, I'd like to welcome our ICEP speaker for this second conference. First, our speaker, Professor Mr. Dr. Lorenzo Quintani from Faculty of Law, University of Groningen, the Netherlands. Welcome, Prof. Second, Professor Dr. Teknan Hilaire from William and Mary Law School, the USA. Welcome, Prof. Third, Dr. Dina Imam Supat from Faculty of Sharia and Law, University Saint Islam, Malaysia. Welcome. Fourth and last, Dr. Seguito Monteiro, Ha from Faculty of Law, University Dili, Timor-Leste. Before the session begins, let me tell you how this conference will run. First of all, every ICEP speaker will present the material for about 15 minutes. And after that, there will be a discussion block for approximately 45 minutes. And finally, the session will be ended by a conclusion. We continue to the next agenda. Ladies and gentlemen, first I'd like to read a brief introduction to our first speaker, Professor Mr. Dr. Lorenzo Squintani. Is a director of the Wubo Occult School of Energy and Climate of University of Groningen, working on energy transition, climate mitigation, and climate adaptation. In this function, Professor Squintani co-developed and implements the research, education, and valorization strategies of the University of Groningen on these themes. He is also head of the energy law section with its 16 full-time equivalents, and also co-director of the Groningen Center for Energy Law and Sustainability. He is expert in environmental, energy, and climate law, in which he performed research by combining doctrinal constructivism with empirical legal research. He regularly advises local, national, European, and international institutions on environmental, energy, climate policy, and matters. So without any further ado, now allow me to welcome Professor Mr. Dr. Lorenzo from Faculty of Law, University of Groningen, the Netherlands, to present the material of An Inconvenient Legal Truth. Does energy law really contributes to sustainable energy system? For about 15 minutes. For Professor Lorenzo, the time is yours.
Thanks a lot. Thanks a lot for this very lovely introduction. I will now proceed with share my screen if everything goes according to plan. Please let me know if that has succeeded. You can now see the screen, and now you should be able to see the presentation in full screen mode. So, good day to all of you. I'm very pleased to be here today, and thanks a lot to the organization committee for having made this possible. I know that there are a lot of challenges in organizing international conferences, and this is a true masterpiece of achievement of organization to have been able to bring people from 3 different continents into, or even more, into this beautiful event today. And I'm actually also very happy to be able to give a follow-up to the visit that my university has had at your country and your institutions in November, and also to the visit that the Ministry for Education, Research and Culture of Indonesia have had at University of Groningen 2 weeks ago, where I had the chance to speak with Professor Engineer Nizam about possible cooperation with the 2 countries. So I'm certain that we will cooperate further in the future. Now, but without further ado, I want to give you a glance at what are the struggles in the field of energy law that we are facing in Europe. That's why the presentation that I titled today, An Inconvenient Legal Truth, echoing the great presentation on the inconvenient truth concerning climate change and what is really going on in energy law in Europe today.
I'm really sorry, Prof.
Yes.
I think the presentation is not able to see from us, the participant. The screen is split to...
I will try to share it again. Let's see if now it goes. Does it work better?
Yes.
Yes.
Yeah.
Thank you, sir.
Yes, thanks a lot for letting me this know. So as you can see, basically the idea of the energy law is to regulate the market. That is how energy law was set up in Europe, to make sure that we have a clear distinction between the production and supply of energy from fossil fuel, and now we are moving toward renewables, to the delivery and transport of energy through the network, therefore, and so to the final consumer, being that customers, private or companies or public bodies, doesn't matter. But what we see now in Europe, that we have challenges at all levels. We are having struggles in moving from fossil to renewable energy sources. We have congestion on the grid, with difficulties to deliver reliable energy through the various parts of the grid nationally and within the whole of the European Union, and that consumers are actually suffering energy poverty issues affecting industry and households alike. Why this is the case, we may ask. what we have to understand is how energy law was developed in Europe. And if we look at now this power plant is being regulated by different perspective, this power plant is located 20 kilometers north of Groningen, where they're living. And if you look at how historically energy law was developed, it started on a sector-by-sector basis. So we had regulation for nuclear, then coal, then we start to regulate electricity, followed by oil, gas. Now we have renewables, energy efficiency, carbon capture, storage and utilization matters, networks operation, trading, but everything was piecemealed in a silos-like approach throughout the history of the development of energy law in Europe. Of course, at each level, we can recognize some common elements, some common policy framework, which then translated to concrete project to implement the policy goal in general, and at installation at the level of specific installations. And later we will see a regulation to deal with environmental damage if something goes wrong.
Sorry, Prof.
Yes, you're still having the problem with the screen?
Yeah, I think that your presentation is not running. We are still on the first page of the presentation.
All right, which is a problem because now I was moving on to the next one. I will try the last time, and otherwise I will just provide a presentation by Art. Are you now seeing the slides with different colors?
Yes.
Oh, yes, sir.
So this is the picture of how energy law looks like. And as you can see, there are different columns and different rows, and each column represents the silos in which energy law was developed over time. The horizontal area shows the conjunction point that they had from the development of policy to the damage control. And there we always see this tension between, on the one hand, public regulation, and on the other hand, the need of self-regulation. On the one hand, the forces of the market, on the other hand, the need of command and control from public authorities, with the role of individuals always being a kind of undefined within this system. Historically, energy law in Europe developed of course, as a growing body from very limited areas to more and more regulatory areas. So the more regulation we passed, the more regulation we needed to enact. So we see a huge growth in amount of rules in Europe. We have a very proactive role at the beginning, but also reactive approach at times. So in which the regulation we use to solve crises, such as we're now seeing today, rather than plan future developments in the future. It started, of course, in Europe with the integration of the resources on and nuclear energy and coal, and it was linked to the idea of sharing resources in order to avoid fighting for the resource and therefore to bring peace on the European continent after the Second World War. This was the basic idea of the European Economic Community, creating an internal market. And this market idea, market structure, liberalization, opening barriers existing among what nowadays are called the member states of the European Union is what has characterized the development of European law. From the second half of the 1980s, we saw, therefore, this focus on breaking barriers, moving competence from national level to the European level, this supranational body that could overcome national interest, and the increasing move toward liberalization to basically shut down state-owned companies and open, therefore, competition on the market. These were the two basic ideas of European law. And we saw wave after wave of regulatory reform aiming at such liberalization, with more and more disjunction between production side, distribution side, and consumption side of the market, which increased over time, as you can see on the various waves on the slides. Now we are in the so-called fifth wave, fifth package in the making, the Fit for 55, which should bring us to this 55% CO2 reduction compared to 2005 by 2030, which is mostly based on a long list of regulatory reform, from emission trading to for sharing in non-ETS sectors, the use of land use and forestry changes, and changes in fuels infrastructure, and of course also carbon border adjustment mechanisms in order to make sure that our CO2 goals can be achieved also when we import energy from abroad, social climate fund in order to address some of the issue of energy poverty mentioned at the beginning, and so forth and so on. But does it really contribute to sustainable energy system? But actually, we are noticing today that the market is failing. The idea of liberalization that we had launched in the 50s and we have continuously pursued over the years increasingly does not seem to have protected consumers and industry in the way that it should have at the wake of the war in Ukraine, where we saw energy prices skyrocketing, leading to a lot of destruction of social and economic structures in Europe and elsewhere, of course. And therefore, we are now trying to understand what are the true problems of energy law in Europe as we know it today. Now, to do this, we can, of course, go back to what the literature teaches us, what is sustainability, and how we can assess whether regulatory reform really contributes to that. And I'm extremely thankful to the work done by Professor Gaines, who in 2014 brought together the knowledge from the Burton report, the ecosystem, social ecological resilience, and the Millennium Ecosystem Assessment approaches to create a theoretical framework which can be used to assess energy policy in Europe. And what is then sustainability? Of course, you are all aware with the idea of balancing the 3P of planet, profit, and people, and therefore to have this integration of conflicting public values when pursuing policy. And this is the basic idea of the Burton report, so to have the development that meets the needs of the present without compromising the ability of future generations to meet their own demands. We see, therefore, a combination of 4 variable in 2 categories, this integration of these different values, planet, profit, and people, and the concept of equity, intergenerational equity, and of course, we also have the importance of intragenerational equity, which both need to be taken into account when assessing whether law contributes to move to a more sustainable system. Next to these 2 criteria of integration and equity, we can derive from the Millennium Ecosystem Framework the idea of ecosystem services, and therefore to look at natural resources as something that needs to be valued to avoid externalities, to avoid looking at the environment as something that we don't have to pay for, and therefore accept the environmental damage and social damage that it causes is something that no one has to be held accountable for. And so there we see that in this theoretical framework, they try to define what are ecosystem services, and then they state also some normative standards, and most notably that such services should be regulated at the proper level of governance, being that private or public, and when speaking of public, being that international, regional, national, or even local, with this preference for local control above international control, but it very depends of the dimension of the ecosystem. So local ecosystem should be governed locally, international ecosystem should be governed internationally. And of course, we can also have to take account what are the drivers of economical change, being that direct or indirect. But this most notably the concept of multi-level governance that we can add to the one of integration and equity to assess whether law is moving towards sustainability. Finally, from the third piece of theory, we have the social ecological resilience theory that says that basically shocks brought to the nature should not endanger the ability of nature to recover from such shocks. So the capacity of a complex adaptive system to absorb shocks while maintaining function. That's the basic idea of the social ecological resilience theory. Now, when you look at it from a legal perspective, means that the law must be able to adapt, to evolve, to cope with new insights on the state of nature, and also new insights on how human activity interacts with nature. And in that sense, therefore, the ability of the legal framework to changes in the understanding of the 3Ps and in changing in our knowledge about the effective effects of human action on the 3P. So this concept of adaptability of law is the base of that we can take from the social ecological system theory. And in that regard, we also see the importance of participation, of public participation, both by means of indirect democracy, so think about representative democracy, elections, and direct democracy, which in Europe has been strengthened with the coming of the Aarhus Convention in 1998, which also means that people must have information about the state of nature, must be able to shape decision-making affecting nature, and must be able to go to court to defend their rights to live in a healthy environment. environment. These are the basic components of the social ecological resilience theory that we can take to assess the ability of laws to cope with the move towards sustainability. So that when you put all together, you start to have a framework to assess whether energy law in Europe today is moving in that direction. And you could see that next to putting the criteria that you just introduced of integration, equity, multi-level adaptability and participation, then you can start to look at the regulatory framework. And I put here on the slides the Treaty of the European Union, which is the founding act on which all of the laws adopted by the European Union to achieve its energy and climate goals have been based. And it's also the one that puts a lot of influence on national level, because EU law has supremacy over national law, and therefore if there is a conflict, the treaties goes first in comparison to national law. Of course, this framework can be evolved over time, so you can always be looking at whether new insights, new approaches should lead to the creation of new criteria to perform our assessment. But for today, we can keep to this one. And I will also be very briefly because of the time at our availability. And of course, looking also only basically at the first one, and on the slide I also provide information about the other criteria, but then you can look at them at your ease after the presentation or the conference. Basically, what do we know about integration? Now, in the principle of integration is enshrined in the treaties with Article 7 saying that the Union shall ensure consistency between its policies and activities, taking all of its objectives into account and in accordance with the principle of conferral of power. So this idea of integrating these various pieces and people, planet, and profit is present in the treaties, but as you can see, it is linked to the concept of take into account, which gives some regulatory leeway to the legislator, and also to the principle of conferral, in accordance with the principle of conferral of power. And the principle of conferral of power poses important limitation to how integration can take place. Now, what is the principle of conferral? The principle of conferral is one of the anchoring principles of European action. The European Union being this supranational body, which member states gave power to act on their behalf and imposing now member states to behave in a certain way. But member states were aware of the risk of giving power to an external body, the supranational organization. So they limited that power by saying, European Union, you can only act to do certain things and in order to achieve certain goals. That's the principle of conferral, limitation of the powers of the European Union. Certain policy area to achieve specific goal set out therein. And the treaties has therefore a series of policy areas all divided by one another, indicating different goals in various areas. And what we see in practice is that this creates a hierarchy between the three pieces, because the aim in the legal basis in the various policy area dictates the content of the measure and also the way in which the Court of Justice of the European Union, which is the sole interpreter of the treaties, interprets the law. The teleological interpretation method is applied by the Court of Justice, so the goal of the act shapes the interpretation of the content of the act, reinforcing, therefore, the goal indicated in the legal basis. And the legal basis that we have in Europe, there are many, and they are all divided by different areas. In energy law, Article 194 indicates one goal, and one goal alone: ensure security of supply. The other piece are less present. And of course, in the debate in literature, let's be discussed whether security of supply should also integrate safety and affordability issues rather than only availability and stability of the energy supply and network. But the truth is that this concept has been used by legislator and policymaker to put the great emphasis on economic growth and availability of energy sources, rather than on a sustainable development of our energy market. And this approach was made possible thanks to the fact that the principle of conferral was putting so much pressure on one specific goal rather than the integration between the various policy goals affecting. And we see this also in other areas. Internal market legal basis, Article 114, has been used as well to pass many network-based regulation in Europe. And also there you see the focus of the goal on market integration, the P of profit, with very little relevance of the other P's of people and planet. And therefore, it's no surprise that today EU energy law has been shaped in an unbalanced way without enough attention to both environmental concern and social fairness, leading to some of the problems that we are now facing today in the wake of the crisis created by the Ukrainian war. The same can be said for the understanding of how participation has been shaped. There is a lot of focus on participation in the European Union, but when we look at who is actually able to participate, who is benefited from the energy transition, we see that is an elitarian movement. Only few people that today can grasp the benefit of the energy transition enrich themselves even further, while the vast majority of societal groups in Europe are remaining marginalized on the sideline. When we look at adaptability, the treaty is of course not easy to be changed, and there is very little to change legislation at secondary level. This has to do with the fact that member states want to retain control on the way in which EU law is developed, and they therefore use comitology procedure to any change in the regulatory framework, which basically means that for any amendment, you have to go back to the drawing table, negotiate, and 2 years later, you will have a better system, if you will have a better one. So very slow decision making. So altogether, we see that the treaties as it's shaped today does not really allow to achieve the normative criteria that we established by drawing them from the literature on sustainability, leading therefore to a fundamental systemic failure at primary level, which then ripples down at secondary level. So it's no wonder that none of the secondary acts that we have in the field of climate, energy, and even environmental law actually are capable of achieving the sustainability goals that we have today. We have to face the inconvenient truth that Europe has a fundamental systemic problem at its heart in its treaties when it comes to the regulation of these matters. Thank you very much for your attention. I will now close the presentation. I hope to be able to answer some questions, but as I have to go to another meeting as indicated before, I will probably not be able to be here during the closing round of Q&A. Thanks a lot.
Okay, thank you, Prof, for giving such an informative and comprehensive presentation for the first session. And for all the participants, we are sorry that Prof Lorenzo is not able to answer your question now because he has another agenda for today. Thank you, Prof, for joining us. Next, ladies and gentlemen, we are now going to listen for the second session of ICEP 2022. Before that, I'd like to read a brief introduction to our second speaker, Prof. Dr. Teknan Hilaire. Dr. Teknan Hilaire is a research fellow at CLCT William and Mary Law School, Williamsburg, Virginia, USA. His academic activities and position are: first, court interpretation and translation, 2017 till 2021, professor constitutional theory and the development of constitutional law, 2016 until now. Third, reviewer, Indonesian Constitutional Court Journal, April 2016 until now. Fourth, senior research and analyst, Center for Constitutional Studies, July 2016 until now. And legal research assistant, Center for Legal and Court Technology, William and Mary Law School, Williamsburg, Virginia, USA, summer 2022. Professor Dr. Teknan Hilaire from William and Mary Law School, the USA, to present the material of environmental law and practice in the United States for about 15 minutes. For Prof. Dr. Teknan Hilaire, the time is yours.
Thank you. That was an amazing introduction. You did quite a good job there. So I would like to thank you for that. Thank you for the time. First, I want to thank the Dean, Professor Ayu, for the trust and the ongoing collaboration. And I also want to thank the Vice Deans of Professor Ayu, Vice Dean of the Faculty of Law, Universitas 11 Maret. I also want to thank the speakers, particularly Professor Lorenzo Squintani, and also Dr. Dina Iman, Dr. Segito Montero, and also the organizing committee for putting up this amazing work to allow this conference to begin and to proceed. Last but not least, I would like to thank the great and amazing students of the Faculty of Law, 11 Maret University. But first, I can't proceed further without sharing my screen, so give me some time for me to share my screen so you can see what I'm about to talk about. Can you see my screen, ladies and gentlemen?
Yes, perfect.
Okay, appreciate that. So just want to do some housekeeping here. Not an expert on environmental issues, but I see it from the constitutional perspective. So my short presentation will be brief, won't take too long. It will be to give you what it is like, the environmental law here in America, and also just give you where the government is heading in its fights against environmental violations and the like. So bear with me here. Like I said, I'll save you the time. I won't go to the details. Just give you an overview, like the title suggests. It's the title, as you can see here, it's Environmental Law and Practice in the United States, an overview. So what specifically I'll be talking about, ladies and gentlemen, today. First, I'll be giving you a the highlights will be the key environmental statutes here in America, and also regulatory authorities, like we used to call them, the agencies here in America. So when we talk about the fight, the protection of the environment, it is pretty much the agency that plays the bigger role in the whole thing. So I'll give you overviews on what it is like, the agency here, the authorities that they have, and what kinds of job they do. And the third, I will talk about the regulatory enforcement. When there's violation, what kind of enforcement is put in place to set the wrong right? And also the famous Chevron case. I'll touch on that a little bit. I won't go to the detail because I'll save you the time. There's a lot of talk in there, so I'll save you the talk. Go straight to the highlight of the case. And down the list, I also have the environmental permits. These are the part of the discussions that I'll be having, and also you have the penalties. And I'll be talking briefly about the renewable energy that the United States is currently struggling to keep up. And I'll talk about the environmental insurance. This is something new. And also I'll talk about the taxes. And then last, I'll talk about the climate change. So without further ado, in America, you can see the US Congress has enacted and amended several environmental status since 1969. So the goal or the purpose of this is to minimize pollution and environmental impact through the imposition of emission standards, operation and reporting requirement, environmental management practices, and environmental impact assessment requirements. So this is the whole purpose of of the US government, to be specific, the Congress. And also, we'll talk about, like I said in my outset, the key environmental standards here in America. Number one, you have the Clean Water Act. So this talked about rivers, lakes, how to fish, how to conduct, how to keep the water in America, how to keep them safe. So you have the Clean Water Act. And also you have the, I won't go through the detail, like I said, you also have the Resource Conservation and Recovery Act. So by act, I mean the law that was passed by the Congress, by the US Congress, to protect first the water, and then the Resources Conservation and Recovery Act. And down there you have Safe Drinking Water. So what's the difference here between Clean Water Act and the Safe Drinking Water Act? So you can't go out there and drink lake water. You can't go out and drink river water. You can't drink river water. So the safe water is the water that comes out of your faucet that you can drink directly. So the US government, through the US Congress, is making sure that the people living in America are not drinking unsafe or unclean water. You also have comprehensive environmental response, compensation, and liability act. So these are the laws, like I said, passed by the Congress. You also have the Endangered Species Act. So this basically protects certain animals and invertebrates and living organisms to protect them. You also have the National Environmental Protection Act. So you have the Toxic Substances Control Act to prevent factories and businesses from dumping toxic substance into the air, the water, the soil, and the like. You also have the Federal Insecticide and Fungicides and Rodenticides Act. So this basically had to do more with agricultural activities to prevent certain farmers from using deadly chemicals to kill the fauna and the flora. That's the whole purpose of that act. And next you have the Emergency Planning and Community Right to Know Act. This I need to a little bit give an explanation because it's a bit not straightforward in the act. So basically what it does is to impose reporting requirement related to storage, use, and release of regulated chemicals and substances. So it is pretty much like the Toxic and Substances Control Act, but this one goes deeper to name what needs to be regulated in the act. So overall, basically, these are the acts that you can see here in America. There are 9. And of course, you have the states regulation that have to comply with these acts. So these are on the federal level, but that doesn't mean on a state level, state cannot enact regulation on their own. But these regulations, even though they are enacted by the states, they need to comply with federal laws, with federal acts, which I just mentioned. So in America, you have the federal level with the Congress enacting laws or act, if you will, and you have a state level that regulates certain activities. So basically, if you're talking about water, lake, it's pretty much a great involvement of the state in that. But if you talk about the air pollution, because it's not specifically related to a state, so the federal government is going to intervene in that. So this is a matter of jurisdiction. So everything related to the air has to be regulated by the federal government, by the Congress. And here, I want to elaborate a little bit here on the agency, like I pointed out earlier. As you can see here, you have the U.S. Constitutions that has to be followed, that has to be abided by. And also you have the Congress that enacts these acts with respect to the US Constitution. But you also have the US environmental laws that are implemented and enforced through regulation, like I said, by the federal agency. The federal agency. Now, these agencies, I'm about to talk about them. There are not too many of them, but just enough to have everything in place. When I say everything in place, it means every activities that harm the environment. So these agencies are put in place. They're given the authority by the Congress to protect the environment. So eventually, sometimes it creates problems between which agency has jurisdiction over what matters. So sometimes you see that a lot. That's why I mentioned the famous Chevron case, which I will discuss shortly. And you have here the first one, the famous one, which is the APA, which is the Environmental Protection Agency. So pretty much this agency deals with everything related to environmental. So here the EPA, implement and enforce most of the federal environmental statements. So the acts that I mentioned, they are enforced by the EPA, which is an agency formed by the Congress. So because the Congress cannot pass the law and apply the law itself, so the Congress passes the law and creates agency to implement these laws. And one of these agencies is the APA, which is the Environmental Protection Agency, which pretty much deals with a lot of environmental issue in America. And underneath that, you have the Department of Interior. So the Department of Interior here administered federal laws dealing with public lands management. So it could be the equivalent of the kantor tanah, something like that in Indonesia, where you had to go to register the lands. So that's what that agency does. But here it is a branch of the government. It's a branch of the government. So like I pointed out, it is in charge of public land management, mining, mineral, natural resources, including various wildlife and plants conservation laws. The third agency that I would like to talk about is the Army Corps and Engineers, or as it is well known as the Army Corps. The Army Corps regulates the disposal of dredged or filled material in waters subject to federal Clean Water Act jurisdictions, as well as activities and structures in navigable water under the river and Alberts Act. So it's basically dealing with the stream of waters and also the navigations in the rivers and Alberts. This is what this agency does. So most likely you have the military very much involved in that to make sure that everything goes according to what the government or the Congress intended. And also you have the National Marine Fishery Service. Like the name suggests here, it's a Department of Commerce, which administers programs for the conservation and management of marine resources. And then you have the Department of Justice, which is well known as the DOJ. So the DOJ here also acts as the guardian of environmental protection here. So it represents the US in litigation arising under the federal environmental law. And also we have the Pipeline and Hazardous Material Safety Administration. Like I said, I won't go through the details. The names are pretty straightforward, so you can see them. I decided to point them out so you can have an idea of where I'm taking you to. So, ladies and gentlemen, like I just said, you have the laws, then you have the agency put in place to make sure that these laws are abided by. And now here, what I would like to talk about is how these laws are enforced. So like I said right at the outset, I said there's two levels. You have the federal and you have the states. So most federal and state environmental law include enforcement provision that authorize the regulator to, number one, pursue administrative, second, civil or criminal enforcement actions. So administrative is because pretty much when you talk about agency, you're talking about administrative law. So there has to be some administrative procedure going on in there. So the enforcement of these acts has to go through administrative procedures. And the outcome of this, you can also have some, sanctions, administrative sanctions. You can also have the license revoked. You can also have some, verbal or written message that tells the violator not to continue what they're doing. Also you have the civil. Civil is just for reparations. You pay money damage. You have to reimburse whoever you did damage to. And also have criminal enforcement, which obviously you have to go to prison and then pay a fine. You can do both also. And then you have many federal environmental laws also allows a citizen to sue. So a citizen can sue the company or can sue a government agency for not doing the job. You can sue them too. Where here the private party can initiate an enforcement action against alleged violator or environmental law. So if the Congress passed a law that is harming a citizen, it can go to a state court and sue them. But you can't do that if it involves air pollution, because air pollution, like I said, it has to be dealt with by the federal government. So a citizen cannot go and just sue the Congress because of some air pollution. It has to do with water and such. And also you have the NGOs that are involved in that fight too. So I'm not gonna go through that. Now that leads me to the famous case. Here, to be very succinct and quick, the Chevron case here is the government, the Congress has given power to the EPA to implement environmental laws. And in this case, there's been a law that was passed by the Congress that really wasn't doing the job for the plaintiff. And so the plaintiffs try to sue the agency to get the law repealed, or if you will, to get the law dropped. So the case was taken to the Supreme Court, and the Supreme Court rules that there has to be they have to follow what the agency said, because like I said, the agency is given the mandate to interpret, but also to regulate what the law says. So if there is a misunderstanding in the law that was passed by the Congress, who is to listen here? Should we listen to Congress or should we listen to the agency? In this case, this particular case, it gives the Supreme Court says we have to listen to the agency, not to the Congress. And this is what is referred to in the legal U.S. legal term as deference. So deference means even though the Congress passed the law, the law is not clear enough, we have to follow what the agency says. So here the agency is going to step in to fill the blame. That's what is basically what it's all about. And then you have here my couple last slide. You have the environmental permits, short for environmental permits. Who is in charge of issuing environmental permits? So first you have the federal, you have the states, and you also have the local regulators who deliver these permits. And then the issuance of the permit is overseen by the EPA. It plays a big role here, ladies and gentlemen. And you also have the penalties. So if you violate it, you don't comply, you don't play by the rules, you'll be punished. I touched on that a little bit. I said there are administrative sanctions, there are civil sanctions, and there are criminal sanctions. And this is an issue that's been going on for quite some time, renewable energy. What is most interesting here is the Joe Biden administration, the government is trying to tell the companies or the energy companies to opt for renewable energy in the near future. So to move away from fossil fuels and everything that depends on that. Like we're seeing now in the Ukraine and Russian war now, there's a huge dependency on fossil fuel. So the government has been trying so hard to move away from that as a replacement, say, inciting and pushing energy companies to dig deeper into that, to make that a reality. Then the last part of my presentation, ladies and gentlemen, I would like to touch on the assurance. That's sorry, not the last one. That's the one before last. So the assurance. If you are a company, if you know that your activities will do damage to the environment, you can go for an insurance. So you can apply for the insurance in America, and then the government will evaluate your activities, and then thereon they will just issue an insurance for your activities. I just wanted to point it out because it's kind of unique and it's very interesting. And it's also you have the tax. You get taxed for your activities, so everything you're doing. So basically, it's the goal of the government is to discourage everybody that is involved in manufacturing or producing toxics. So they make they tax you when you use equipment or material that facilitates your activity. So by taxing you, maybe it deter you, it prevents you, or it discourages you from pursuing the activity. So you produce, you do less harm to the environment by having those big taxes coming your way. And I guess this is the last one now. So here's something that is really interesting, because you are here, the US government, he's pretty much involved in the fight against climate change. But to be really honest, the government hasn't taken any sufficient step toward that goal. As you can see, to date, the US has not enacted a comprehensive legislation to address climate change. So there's no law you find, no act, no regulation that says this is the law the US government is committed to climate change. As you can see, the previous administration, the Trump administration, didn't even believe in climate change. So this, I won't say there's nothing, but it's just a little bit efforts toward that goal. Certain federal and states measures have been taken to mitigate climate change risk. However, the Biden administration is taking steps to prioritize climate action at the federal level. But also at the same time, you also have the US is a party to the United Nations Framework Conventions on Climate Change and the Paris Agreement. But it's not, strangely, the United States is not a part of the Kyoto Protocols. So what the Kyoto Protocol is, it basically asks about 192 countries to reduce their the GHG, which is greenhouse gases emission by 2020, by 26. But the United States is not a part of it. It's not. So it wasn't until recently that President Joe Biden had decided to commit to reducing that. So the US is not part of the Kyoto Protocol yet. That tells a lot. So I wanted to finish my presentation on that message, even though at home, the US government is doing a lot to protect the environment here, but internationally, US is not doing very much. So there's much to be done. The path ahead it's a long way. There's still a long, there's so much to be accomplished. And US is not there yet, but it's still struggling to get there. Thank you very much.
Thank you very much, Professor Dr. Hilaire, for giving such an informative and comprehensive presentation for the second session. Again, I want to remember all of the participants. If there is any question regarding the session, will be discussed on this discussion blog later on after all the speakers already present their presentation. Once again, thank you, Prof, for the session. Let's go to the next agenda. We are now going to listen to the third session of ICEP 2022. The speaker for the third session is Dr. Dina Imam Supal from Faculty of Sharia and Law, University Sains Islam, Malaysia. Dr. Dina Imam Supal graduated from the Birmingham Law School, University of Birmingham, UK. She is presently a senior lecturer at the Faculty of Sharia and Law, Islamic Science, University of Malaysia, Nilai Negeri 9. She holds a degree in law and a master in law from the University Kebangsaan Malaysia. Dr. Dina was once deputy dean and head of program at the faculty and responsible for the staff, student, and program development. Dr. Dina here is to present the material of climate change and displacement in Malaysia for about 15 minutes. For Dr. Dina, the time is yours.
Okay. Assalamualaikum warahmatullahi wabarakatuh and a very good afternoon. Thank you, Miss Moderator. And I would like to thank the organizer for the invitation to join our session today. And I would like to bid a good day to my fellow presenters. And I hope everyone is feeling good this afternoon, despite a long day. And I am sure that everyone is looking forward for the weekend, for the coming weekend. So my presentation is on climate change and displacement, a Malaysian perspective. So I will share the screen. Okay, can you see my screen?
Yes, Prof.
Okay, thank you. So the content of my presentation would be the introduction And I will speak a little bit on Malaysia's contribution to climate change. I will explain briefly on displacement, including the situation in Malaysia, and some input on Malaysia's effort towards zero emission, and then I'll come to the conclusion. Okay, as an introduction, I'm sure that everyone here is aware of climate change. I'm sure that you know what climate change is, and this one that I share with you is the definition given by the United Nations. So climate change refers to a long-term shifts in temperatures and weather patterns. Yeah, it looks natural. Yeah, it looks natural because at some point, due to the solar cycle, we can see some changes in the weather patterns. But if it becomes a long shift, then we call it climate change. And since the 1800, climate change is primarily due to human activities, including the burning fossil fuels. We've been driving cars and all kinds of vehicles, and this has become the main driver of climate change. Okay. Sorry, it's not changing. All right, okay. So climate change has several different effects on different spectrum of our life. It has some effect on biodiversity. We have seen that the climate change modify the conditions and cycles of plant reproduction, and cause the scarcity of resources and climate and changing the habits of migratory animals. But before that, I would like to ask, I'm not sure if you, I hope you can follow my presentation. I'll be as slow as possible so that you can follow. If you need to stop me, you can do that. Yeah. Okay. The other effect of biodiversity, climate change on on us is the effect on the ocean. I'm sure that everybody is aware that the sea level is rising by 21,000. Today is 2020, so maybe around 78 years more. The level of sea, the sea level will rise by 1 meter. Why do we have to worry about this? Because the rise of sea level poses a serious threat to the coastal life. We will have more intensified storms, bigger flood. It will damage coastal areas, and in many cases, cities or coastal areas are where large population centers. So they are located in those areas. And furthermore, we have a wildlife habitats in the coastal area, and this can be affected by the rise in the sea level. And the other aspect of the ocean, which is affected by the climate change, is the acidification of the ocean, because the ocean capture more or a large amount of carbon dioxide. So the change in the water content, the quality of the water will affect the adaptability of our coral reef and also seashells. Climate change also affect us as human. I believe you understand how climate change affect the global economy. Yeah, because we have less food, less resources, less energy. it lead to new conflict. People are competing with each other to get more food. And since there is rising sea levels and floods, some countries, especially those countries which are lying low in the ocean, they are at this front line, and they have these issues of submerging in the ocean. So they become the people of these countries, of these states, become climate refugees. And by 2050, it is estimated that the world will have between 200 and 250 million of climate refugees. So refugees are basically people who cross international border to seek refuge because their own country cannot provide that protection because they are facing persecution. But in the case of climate refugee, there is no actual persecution. There is no human rights violation as in the normal refugee, but they cannot seek that protection, or they cannot be safe in their own country. So they have to move. They have to get a new place to stay. So in some countries, people did become displaced from one district to another district because the current district becomes inhabitable. And refugees, for example, are people who are living in climate hotspots, and they have lack of resources, and they are included in people who are affected by this hostile environment. I'm not sure if you have heard of the Rohingya refugees who are in Bangladesh, for example. Bangladesh is a host to a huge number of Rohingya refugees, and what they did to free up some space in their own country, they have built a new place for the Rohingya in an island, but this island is in an open sea, and the island is at risk of being savaged or damaged by what we call the weather, by harmful weather or by ravaging weather. So it's that island which is intended for Rohingya refugees to stay becomes inhabitable. So refugees from the mainland of Bangladesh refuse to move to this island because they are unsure, they are not confident of the safety. Okay, there is also effect of the climate change on the weather. I remember when I was small, we can predict the monsoon season, and we have a few months where we have very little rain, where we call the dry season, approximately between mid of May to September or October, mostly until September. So this is the time where we receive very little rain, and where we can organize or schedule outdoor programs. But today, due to climate change, Malaysia receives lots of rain throughout the year, and it's impossible to identify or to get even a week without a rain. So it's quite difficult to schedule events in which we can have rain free. But on the other hand, yes, we love rains. I mean, we need all the water, but it comes with some downsides. Yeah. So besides rain, we also have droughts because of the climate change, and we have heat waves, and we have less water in some regions, and the deserts are expanding. Yeah, some deserts getting bigger and bigger, so we have less land to grow our food, and this has obviously harmed the food production. And like I mentioned earlier, besides all this rain, because of the extra rain that came, we have floods, hurricanes, severe storms, yeah, and to date we have the natural hazards or the natural disaster is accounted for 50% of all disasters. So we have man-made disasters, we also have natural hazards and natural disasters. So 50% of all these disasters are natural hazards, and it is also accountable for the 45% of all reported death and 74% of all reported economic loss. Okay, so what is Malaysia's position to climate change? In 2019, this is the most recent data that I have. Hopefully there is a more recent one, but I only got this one. So we emitted 389.11 million tons of carbon dioxide. And this is equivalent to less than 1%, less than 1% of the global emissions. Even at less than 1%, Malaysia is at the 23rd largest, largest emitter. So just imagine, as a small country with less than 35 million people, Malaysia is at the 23rd place as the largest emitter of carbon dioxide. And we know that Malaysia is, and we know that the Paris Agreement wanted everyone to limit, to increase our effort to make sure that the world temperature will not rise more than 1.5 degree. So if it has to rise, it should be below 2 degrees. But we want to do it, we want it to be, the Paris Agreement want it to be less than the maximum to be 1.5 degrees. Why is that so? Because if we reach a rise in the temperature to 2 degrees, it will affect the biodiversity, and more species will become extinct. Okay, so I'm going to explain displacement because there is a link, a strong link between climate change and displacement. This is because these hazards, the extreme weather events, the droughts, the desertification, the sea level rise, the cyclones, will force people to leave their homes because they have to move from a place where they are at risk of natural hazards to a place where they can seek refuge. In some place, they only move from one district to another district, but still within the border. But in some states, they have to cross international border to get protection. 1 in 7 people is a migrant, and more people today move because of disaster. Yeah? And migrants are worst affected by disaster, not only because they are exposed, not only because they are just exposed to the disaster, but because of their position as migrants, they are less prepared. They are not that prepared to face the natural disaster. So if when they are less prepared, they are unable to cope and recover from the impact of disasters. Okay, if you are if you like to see the map, I'm sure you know where the Pacific Island is. You know the Pacific Ocean. So in this Pacific Ocean, we have lots and lots of small islands. In 2015, Vanuatu, a small island in the Pacific, was hit by Category 5 tropical cyclone. And this was a very strong cyclone. And the cyclone affected more than 160,000 people, making 75,000 of them without adequate shelter, and 110,000 in need of fresh water. I need you to imagine their situation, where you are in a small island in the Pacific Ocean, where you cannot find anywhere to save yourself when cyclone hits your place. Okay, the small island developing states, SIDS, including Vanuatu that I mentioned earlier, are vulnerable to the effect of climate change because of their location. So we also have other countries there. We have Tuvalu and Kiribati. These are some other examples which are affected. And these two countries are projected to disappear by 2050. Just imagine living in an island where you were told that your land will disappear by 2050. So I am sure that if we are in their shoe, we will be thinking about finding other place, finding a new place to seek refuge or for our survival. Because they know that the place that they are currently residing is at the risk of submersion. Okay, Tuvalu is in the Pacific Ocean between Hawaii and Australia, and it's profoundly affected by climate change. They have serious flood issues, which cause massive destruction. There is also a problem of saltwater contamination because of this flooding, saltwater contamination in inland soil. So it kills the coconut trees, while coconut trees is one of the most important trees in their life for food. And it also brought a drought because of we have less water, because Tuvalu has less water. So of course they can desalinate the seawater, but that is too expensive for Tuvalu. So at one time when they have very little fresh water, they were forced to shut down the schools and hospitals. So they turned to New Zealand and Australia for help. Another country, Kiribati, is also another small island in the Pacific Ocean, located between Hawaii and Australia. It's an impoverished nation, and only 25% of them have access to sewer systems. So if you have, so you can imagine when people do not have this proper sewer system, it will affect the hygiene and also health of the community. And imagine that the majority of the people do not have bathroom facilities. And like Tuvalu, Kiribati is also deeply affected by climate change, even though they contributed very insignificant amount to the emissions of GHG, greenhouse gas, because very little people in Kiribati use fuel, fossil fuel, but they are the one who is suffering from the effect of climate change. Yeah? And in 1999, 2 of their islands has already submerged. Submerged. Okay, they also have saltwater contamination, and they have long droughts where they have less drinking water. Okay, and from all these events, scientists projected that this unprecedented event will become norm. It will not be an exceptional event anymore, because we've seen so many, and there is high possibility that more and more hazardous weather will beat us. Okay, and as I mentioned earlier, we're going to have more climate refugees, and climate refugees come with its own challenges to the receiving country. And if they are not a climate refugee, if they are only displaced person within the state, they also have problems. Malaysia had a bitter experience last year in December 2021, and also in early and middle of 2022, where we had a very heavy downpour for many days, non-stop. And first we had this flood, a huge flood, and the loss, the casualties, the loss, the economic loss, we suffered around 15 billion of loss. And almost 70,000 people are affected. They are displaced, relocated to the temporary shelter, but many of them are also relocated because their place become inhabitable. And we also had deaths and people missing. And prior to this flood, Malaysia also experienced other climate-induced disaster. For example, we have landslide, mudslide, and due to these events, many people has been displaced here, including the indigenous people. Okay, so we are going to, because we know that we cannot stay business as usual. Something need to be done. We have been reminded that something need to be done, and we are going to see whether what laws in Malaysia govern carbon emissions, to see whether Malaysia has the tool to contribute to protect ourselves from further climate change, further disaster due to climate change. Okay, we have the Environmental Quality Act 1974, EQA, and this is the main legislation that governs the protection and conservation of the environment. And specifically under section 21 and 51, the minister has the power to create regulation to specify the acceptable conditions for the emission of environmentally hazardous substance. So the minister has that power. So they can develop a standard, they can set the standard at what degree, how many percent, or how much can you emit, can our vehicle emit, or our activities, our factories emit. Okay, so under the section 21 and 51 of the EQA, the minister created several regulations, and including the Environmental Quality Clean Air Regulation 2014. And this regulation provides that an owner or occupier of a premise involved in any activity or industry listed in the first schedule of the regulation, including power plants, waste fuel plants, asphalt mixing plants, and other, to incorporate measures to reduce their emission. So first, for the air, they ask these plants to reduce the emission. And then they have further provisions. They monitor the air pollution control system, offenses, penalties, and others. And also they make sure the regulation ensures that owners of premises must now be prudent in its operation. So they have to follow. They make sure that owners and premise follow or comply with the regulation. Yeah. And then there is also regulation to govern the emission of pollutants from different type of vehicles. So previously, earlier on, I discussed about the plants, the building, the manufacturer, but this time it's vehicles, such as the motorcycle, such as car, those equipped with petrol and diesel engines. So the law prescribed the limit of pollutant emission, and in the long run, if every vehicle comply with this regulation, it will reduce the amount of harmful pollutants emitted in the Malaysian air. Okay, we also have a new act, the Renewable Energy Act 2011, and this is the act that aim to increase the production of green energy. So it provides incentive for generation of electricity using renewable resources. Yeah? For example, they use biodiesel, or when you use what you call the solar cell. Yeah, you can do, if we do that, if we use that, if we take the effort to install our own solar panel, we are able to get some sort of incentive under the REA 2011. Okay, Malaysia is also a party to the Paris Agreement. So this requires Malaysia to reduce the emission of greenhouse gases by 45% by 2030. That is only, what, 7 years away, or 7 to 6 years away. And we are not sure. I do not have the data of where we are now. And under this 45% reduction of GHG, 35% is unconditional, and the remaining unconditional means by hook or by crook, you have to reduce that. But another 10% is conditional upon the receipt of climate finance, technology transfer, and capacity building. So we need help from the developed countries, from Japan, from America, from the European, developed European countries, to help us with the technology transfer and capacity building, and also the climate finance. Okay, and Malaysia has determined, has updated our nationally determined contribution under the requirement of the Paris Agreement. So we determined that, Malaysia determined that it will increase the unconditional reduction intensity by 10%. Yeah, and then so maybe next time because currently we have 35% unconditional, so we want to reduce it to increase and to reduce. Okay, 10% is conditional, 35% is unconditional. Where is it? Okay, so we want to do it as 45%. So there is no, so that we can reduce, we don't have to take that conditional reduction anymore. That's what it means. Okay. Under the NDC, Malaysia also expand the greenhouse gases coverage. So we have all these kind of gases that we want to cover as GHG. So we want to control the emission of these gases into the atmosphere. Okay, so these are all the commitment, but and the Ministry of Environment and Water, and also the Ministry of Finance and Bursa Malaysia are working to develop the voluntary carbon markets. The VCM is a form of is a platform that conduct carbon credit trading between grid asset owners and others with to move towards low carbon practices. But this has not been introduced yet. They are still in the pipeline. Okay, we also have this. We also have this effort to introduce the long-term low emission development strategy, but this is still in the development phase. Okay, and our industry leaders, Petronas and Shell Malaysia, have shown its commitment by making a few steps towards improving energy efficiency, provide low carbon energy, develop emission reduction technologies, and reduction of hydrocarbon flaring and venting. Okay, so of all what happened to Malaysia, to other countries, with all the climate change, the climate refugees that we have, the displacement that is happening, we should know that this is a serious matter. So we have to work together efficiently in a sustainable way to make sure that the future generation will be able to enjoy the environment. It's said that every disaster movie begins with a scientist being ignored. If you watch movies, you've seen, you will see all these scenes where scientists were ignored by the politician and whatnot. So it's time for us to really listen to the scientists, listen to those who know, who works to prevent climate change, so that Malaysia and also other countries will not experience a more escalated disaster in the future. So that's all my presentation. Thank you for listening. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Dina Imam Supa, for giving such an informative and comprehensive presentation for this session. I want to remind all the participants again, if there is any question regarding the session, will be discussed on the discussion blog. Once again, thank you, Dr. Dina, for the session. Without any further ado, we will continue to the last session of this conference. The first speaker is Dr. Seguito Monteiro, SIMH from Faculty of Law, University Dili, Timor-Leste, to present the material of implementing legislation and law enforcement for about 15 minutes. For Dr. Seguito Monteiro, the time is yours. Halo, Dr. Sugito.
Dalam
Ya.
hal ini mungkin ini dalam hukum internasional konvensi hukum laut internasional 82 dari 168 negara, Timor Leste sendiri sudah meratifikasi UNCLOS 1982 dengan diratifikasinya Undang-Undang Nomor 7 Tahun 2002 tentang batas maritim. Kemudian resolusi Parlemen tanggal 17 2002 dengan diberlakukannya Undang-Undang Maritim. Kemudian kerjasama sukarela dalam menangani illegal fishing antara Indonesia dan Timor Leste. Dari semua perjanjian tersebut, Timor Leste sudah menggunakan semua. Dari Konvensi Hukum Laut 1982, ada 8 zona maritim yang telah diratifikasi, di mana 8 zona maritim antara lain perairan pedalaman, laut teritorial, zona tambahan, CEE, landasan kontinental, laut lepas, dan perairan kepulauan, serta area kawasan. Dari zona maritim tersebut sudah ada implementasi legitimasi hukum nasional, namun masih perlu dikaji terutama penegakan hukumnya. Sehingga dalam Konvensi Hukum Laut 1982 pasal 21, di mana hukum dan peraturan dan negara pantai yang berkaitan dengan lintas damai, di mana negara pantai dapat membuat peraturan perundang-undangan sesuai dengan ketentuan konvensi ini. Peraturan hukum internasional lainnya yang berlainan dengan lintas damai melalui laut teritorial mengenai semua atau setiap hal, sehingga keselamatan navigasi dan pengaturan lalu lintas maritim, serta perlindungan alat-alat pembantu fasilitas navigasi serta fasilitas atau instalasi lainnya. Kemudian perlindungan kabel di bawah laut, serta konservasi kekayaan laut. Kemudian pencegahan pelanggaran peraturan perundang-undangan perikanan negara pantai, serta pelestarian lingkungan negara pantai dan pencemaran pengurangan dan pengendalian pencemaran, serta penelitian ilmiah kelautan dan survei hidrografi. Namun dalam hal ini pencegahan pelanggaran peraturan perundang-undangan, bea cukai, fiskal, imigrasi suatu negara pantai dapat dilakukan. Kemudian dalam hukum nasional, Timor Leste sendiri telah meratifikasi lewat Konstitusi Republik Timor Leste pada tahun 2002. Kemudian diturunkan melalui Kodiku Penal atau Kitab Undang-Undang Hukum Pidana Timor Leste, serta Kodiku Penal Prosesu Sivil atau Kitab Undang-Undang Hukum Acara Pidana. Kemudian peraturan pemerintah mengenai peraturan Kementerian Perikanan. Dari semua peraturan yang dilakukan untuk menjaga kedaulatan atau untuk menjaga wilayah teritorial Timor Leste, di mana zona wilayah perairan atau yurisdiksi yang sering terjadi illegal fishing itu terjadi di laut teritorial, di mana zona ekonomi eksklusif Laut Timor Sea yang sering terjadi illegal fishing yang melibatkan negara-negara antara lain Kamboja, Vietnam, Thailand, China, serta di Laut Timur dekat Australia dan Indonesia. Namun selat bagian timur, Pulau Wetar, Pulau Kisar, dan Leti, bagian selat Ombai, perairan timur juga sering terjadi illegal fishing. Mengapa terjadi illegal fishing? Karena kebutuhan sumber bahan baku di negara pelaku illegal fishing sudah menipis akibat praktek industrialisasi kapal penangkap sehingga daya tumbuh ikan tidak sebanding dengan jumlah yang ditangkap. Yang kedua, sistem monitoring atau salah satu upaya di mana pengawasan yang dilakukan oleh Perikanan Timor Leste dengan adanya bantuan dari FAO yang sudah memasang sport tracker di dua kapal itu, namun informasi tersebut di mana sampai saat ini belum bisa memadai untuk mengontrol kapal-kapal yang memasuk wilayah teritorial Timor Leste. Yang ketiga mungkin di sini adalah terbatasnya dana untuk operasional pengawasan baik di Departemen Kelautan, Polisi Maritim Timor Leste dan Angkatan Laut Tentara Nasional Angkatan Laut Timor Leste, serta keterbatasan di mana Angkatan Laut Timor Leste dan Polisi Maritim sangat kesulitan dalam hal ini kapal-kapal yang digunakan sangat minim dan sangat kecil sehingga negara-negara maju menggunakan itu sebagai kelemahan untuk menangkap ikan di perairan Timor Leste. Terus harga ikan semakin naik sehingga melakukan illegal fishing di perairan suatu negara dengan sistem monitoring yang lemah. Terus lanjut Laut Timor Leste terbuka, tidak ada penjagaan dan karena lemahnya SDM sumber daya manusia dan peralatan yang dimiliki oleh institusi. Yang terakhir di sini pengawasan yang lemahnya pengawasan Polisi Maritim dan Angkatan Laut FFDTL yang di perairan Laut Timur adalah salah satu faktor penyebab maraknya kasus illegal fishing di perairan Timor Leste. Oleh karena itu, kapal yang dimiliki Angkatan Laut dan Polisi Maritim Timor Leste sekarang digunakan kapal berukuran kecil sehingga sulit untuk mengejar para pelaku illegal fishing. Yang di sini kita melakukan untuk modus operandi illegal fishing di sini adalah di mana ada kasus tertangkapnya 15 kapal penangkap ikan asal Cina oleh kapal Ocean Warrior yang berhasil menemukan di titik 150 kilometer, namun di perairan Selat Timor Leste. Namun izin kapal-kapal Cina yang dimiliki perusahaan Marina Enterprise tersebut yang beroperasi memiliki izin dari Kementerian Perikanan Timor Leste. Namun izin tersebut disalahgunakan karena terbukti ribuan ekor hiu di setiap kapal sehingga melihat dari cara memasang jaring dengan insang di bawah yang pada dasarnya memberatkan dasar laut seakan menangkap ikan. Sangat jelas bahwa mereka hanya mencari ikan hiu. Namun dalam proses peradilan di distrik Baucau, akhirnya mengambil keputusan untuk melepaskan ke 15 kapal ke negaranya dengan denda $100,000 US. Dengan konvensi atau dasar hukum dalam hal untuk penegakan hukum, dasar hukum penangkapan kapal dilakukan oleh negara pantai berdasarkan pada pasal 73 Angklo 1982 dalam rangka melaksanakan hak berdaulat untuk eksplorasi konversi pengelolaan sumber daya hayati di zona ekonomi eksklusif. Negara pantai dapat memberhentikan atau memeriksa dan menahan atau memberhentikan dan mengadili kapal asing sesuai dengan hukum nasional yang telah diratifikasi dan melalui Konvensi Hukum Laut 1982. Yang kedua, dalam hal ini kapal dan awak yang ditangkap itu harus segera dilepaskan setelah adanya uang jaminan layak atau bentuk jaminan. Yang ketiga, negara yang menangkap itu atas pelanggaran di JE tersebut tidak boleh menjatuhkan hukuman kurungan atau tidak boleh hukuman barang lainnya. Yang terakhir, di mana negara yang menangkap harus segera memberitahukan negara berbendera via diplomatik. Dalam kasus ini, kondisi perikanan Timor Leste di mana illegal fishing atau over capacity illegal fishing sangat tinggi. Kemudian pengelolaan atau input control de facto open access sangat terbuka, sehingga kapal-kapal asing sering menggunakan itu sebagai dalil untuk memasuki wilayah teritorial untuk melakukan penangkapan kapal asing. Dominasi kapal asing itu dilakukan karena Timor Leste sendiri tidak mempunyai kapal-kapal yang besar sehingga tidak bisa mengontrol kapal-kapal asing, serta ekonomi pelaku usaha sangat menurun. Di Timor Leste banyak pelaku usaha dalam hal perindustrian perkapalan sangat menurun, sehingga industri pengelolaan nasional tidak ada. Tidak ada, tapi hanya kapal-kapal kecil yang berlaku, tapi itu pun tidak didukung oleh pemerintah, sehingga nelayan kurang perhatian dari pemerintah. Tingkat pelanggaran di peraturan perundang-undangan perikanan kebanyakan ada di Laut Timor atau Timor Sea, yang sekarang di mana perbatasan langsung dengan Australia dan Indonesia. Daerah-daerah itu yang digunakan oleh negara-negara yang mempunyai teknologi tinggi untuk melakukan pelanggaran perikanan di daerah-daerah. Namun di Selat Betar dan Selat Ombay itu juga ada nelayan-nelayan Indonesia yang sering memasuki wilayah Timor Leste. Kasus-kasus tersebut sering dilakukan di wilayah tersebut, sehingga polisi maritim dan polisi Tentara Nasional Timor Leste menangkap. Namun karena ada kerjasama dengan Indonesia, nelayan tersebut hanya dideportasi atau dikembalikan ke negara asal Indonesia. Dalam kasus-kasus yang selama ini dilakukan di pengadilan distrik, baik di distrik Dili, distrik Baukau, hanya semua itu dikembalikan ke negara asalnya. Sehingga dari tertangkapnya 15 kapal itu semua dikembalikan. Saya rasa itu yang saya sampaikan. Yang terakhir mungkin perkuat aturan dan fasilitasi baik sumber daya manusia dan sumber daya seperti kapal itu mungkin harus dilengkapi. Itu yang mungkin saya sampaikan. Terima kasih karena mungkin jaringan saya akhiri. Selamat.
Thank you, Dr. Sugito, for the presentation. Terima kasih untuk presentasinya yang telah memberikan pengertian dan juga penjelasan mengenai keadaan di Timor Leste.
Ya, terima kasih.
Baik. For ladies and gentlemen, now we have come to discussion session. For ladies and gentlemen who want to ask question, please don't hesitate to use the raise hand feature and then on mic or just type your question in the chat box. I'll open for the question first and the speaker will answer the question and so on as long as we still have time. So for all the participants that want to ask a question for the speaker can write it down on the chat box or open your mic. I'll open for the first 3 questions. All right, there is Mazlan Abasi. For Mr. Mazlan.
Yes. Can I ask some question?
Yes, please.
Okay. I have a question for Dr. Dina Imam Supat. Hello, doctor, and good afternoon. I come from Sebatik Island, near from Sabah, Tawau. And then I wanna ask you some question about why Malaysia become 23 country contribute in climate change, and what activity in Malaysia that contribute in climate change.
Okay. Thank you for the question, Mazlan.
Yes.
Malaysia becomes the 23rd contributor to carbon dioxide because of the use of fossil fuels. As we know, Malaysia is a producer, or is an oil producer. So the cost of petrol is cheaper than many countries. We also produce our own cars. So we have cheaper cars in the country. So we have both cheaper cars and cheaper fuel as compared to so many countries around the world. So more people are able to buy cars, and then our public transport at one time is not very good. So we have so many people able to buy cars. So they do not want to carpool. So that is the major contributor to the emission of greenhouse gas. Mostly it comes from the fossil fuel. So if just an example, yeah. If you come to a residential area, if they have a terrace house, so that terrace house is dedicated for one house, one car. So if you have, ideally, one house should have one car, but you will see that one house will have 3 cars. If their family, their children are living with them, each children can have car. So one house could have 5 or 6 cars. So each of these cars will consume petrol. So that is why we are the 23rd contributor of the greenhouse gas. I hope I answer your question, Mazlan.
Yes, doctor. I know. Thank you for the answer, but what do you think about farming in Malaysia that contribute to the emit carbon dioxide, or
Yes.
or just a little?
I'm not sure how many percent that contributes to, but I'm sure it contributes a significant amount of carbon dioxide, because the traditional practice of farming is that after they harvest, they will burn all the dry leaves. Yeah, for example, after you harvest the paddy. Yeah, after you harvest the paddy, so the remaining one you will burn. Yeah, so it's not only for paddy but also other plantation. For rubber trees, before you replant, at the end of 20 or 35 years before you replant, you cut all the trees and you burn them before you replant. Yeah, so each time you do that, you will also contribute to the increase of carbon dioxide, or one of the greenhouse gases. And the other contributing factor is the livestock. Livestock also livestock also contribute to, and then we eat the livestock. Malaysians eat lots of meat. Yeah? That also contribute to the greenhouse gas. Okay, Mazlan?
Yes, doctor, thank you very much for your question, for your answer.
Thank you.
All right, thank you, Dr. Dina and
Mr. Mazlan for the question and the answer. Next, we will have to question. For the participant who want to ask, can raise their hand or maybe just write your question on the chat box. Anyone? Anyone want to ask their question? Oh, okay, we have Miss Willy Naresta.
Thank you, moderator. I would like to ask question delivered to Prof. Teknan. Could I?
Yes,
Yes,
please.
please.
Please proceed.
Okay. Thank you for the opportunity. Prof. Teknan, we understand that regulation will grow time by time and finds a balance point with society's need. And but however, what's your opinion if the energy field regulation constantly changes? Is that normal, and is that also happen in the USA, or do you have some theories to explain this circumstance? Because this happens in Indonesia, for instance, in market regulation of geothermal energy, ruling about heat price changing almost every 1 year, and it has been challenging for the developer. Thank you.
So, if I get your question correct, you said changing regulation, right?
Yes.
So you said Indonesia is it happens on an annual basis. Is that correct? Yo, did you hear me? Did you hear me?
I'm sorry, because my internet connection has lost for
Can you ask your question again, please?
Okay. So my question is about the regulation that constantly change. What's your opinion? Is that normal? And is that also happen in the USA? Or do you have some theories to explain this circumstance? Because this is happened in Indonesia, especially in geothermal energy law, because regulation about that changing almost every 1 year.
Thank you. Thank you, Miss. Is it Willy Naresta?
Yes, it's correct.
Yeah, that's a good question. I appreciate you taking the time to come up with such a brilliant question. Changing the regulation one thing you need to know in America, the law doesn't change that quickly. It takes some time. If you follow my presentation, I gave you the acts. These acts, some of them has been put in place a long, long time ago. Okay, like the Environmental Protection Act. It was enacted back in the 60s. So to this day, this act is still in force. So the regulation doesn't really change that quickly in America, as in comparison with the Indonesian context, where the law is always changing on the, sometimes you have the national level and also on the provincial, regional level. It's always changing. But this brings you to, the debates as to whether or not the law has to be evolving based on the human activities. It has to adapt. The common law legal system is it's a legal system that is really it's stuck, doesn't change that much. It takes a great deal of legal opinion, judicial opinion to fill in the blank. So as you see sometimes when there's emptiness somewhere, they'll fill that in with the judicial opinion, with a decision, with a court decision, which is not the case in Indonesia. In Indonesia, you have a law that has been enacted. If it is not working, they will just repeal and replace it with a new one. Not to mention the junto. So there's a lot of juntos. We have the laws and they have juntos and they have repeal. But in the end, you might have some, intertwining regulations. Sometimes you have some regulations that are just colliding or clashing, as you say. But this also, there's a good aspect to it because it's a human activity, like I said. So the law should reflect the activity. If there's a lot of activities going on, there should be, an update in the legal system. But in America, like I said, this has been compensated for with judicial opinion. So it is something, it depends on the legal system you put in place. In Indonesia, you have the civil, it's civil, it is written, and it's changing. In America, it is not written. It is, what should I say? It is a case law. Sorry, so you can scrap that. It's a case law. It's based on the case. You have the judicial opinion that goes with that. So it's not different from the Indonesian context. The only difference is it's not like they're going to enact a new law, if you understand what I'm saying. It's not like it's going to be a new law. The Congress is going to convene and enact new law so agencies can follow. No, agency can make their regulations sometimes, but they stick to the main law, which doesn't change that much. If I may answer that to your question. If you want to follow up, you can see follow up. I'll be glad to answer more follow-up questions from you.
At this time, your explanation is very clear, Prof. Teknan. Thank you so much.
All right, thank you, Prof. Teknan and Ms. Willy for the question and the answer. Next, we will have one question. Is there any participant? Okay, for Mr. Abelard, please open your mic.
Okay, hello Bu Dina. I have a question. Years ago, Malaysia got damaged by the smoke because of the Indonesian forest fires. And I would like to know, in law point of view, how Malaysia solved this situation about facing the environmental damage. But it happened because of the other state's activity, or in other words, the damage did not happen because of Malaysia itself. Thank you.
Abelard, are you directing the question for me?
Yes.
Sorry, I did not hear the question. It was not clear.
Okay, let me repeat again.
Or is it possible for you to type the question?
Yeah,
I think
okay.
not sharp. Sorry.
Okay, let me type the question. Okay, I have written in the chat box. Thank you.
Okay, thank you for the question. Yes, we before the pandemic, we had this experience of the, what do you call it? We call it jerebu. I suddenly forget about the term. we have this this problem of smoking, haze, all right, the haze, the transboundary haze that travels from other territory to Malaysian territory. What we know is the Asian country under the camaraderie of ASEAN had this agreement among themselves that we will not do anything within our border that will have a negative impact to our neighbors. So even though Malaysia has experienced all the haze for a few years, I think because of a good relationship, because of the tolerant that not only the people, most importantly the what you call the leaders in the Asian countries, so in the ASEAN countries, yeah, ASEAN, ASEAN. I think that helped them to solve the problem. We do have health related problems during that time, but as neighbors, our leaders will always remind Malaysians not to do or to respond in aggressive way. But Alhamdulillah, when the pandemic came, it has not happened until today. So legally, we have not done anything, but we know because the problem does not solely come from the people of Indonesia, because we also have Malaysian corporation operating in Indonesia that burn the forest to make way for plantation. So we have Malaysian-owned corporation. I mean, the companies is wholly owned by Indonesian, but Malaysian have shared in the company, and those companies, those corporation, are the one who burn the forest, to cut it short, because they think that is the cheapest way of clearing the ground for plantation. So yeah, legally we have not taken any action against Indonesia. That's very sure. That's what we are very sure of. But like I said, the spirit of camaraderie between among ASEAN leaders make it possible to solve the problem amicably, yeah, peacefully. I hope I answer your question, Abelard.
Okay, thank you so much, Bu Dina, for the explanation. Thank you.
All right, thank you, Mr. Abelard and Dr. Dina, for the question and answer. Maybe we still have time for one question.
All right, we have one question in the chat box here. The question, wait a minute. The question is for Mr. Monteiro. Is Mr. Monteiro in the room? Mr. Monteiro, there is a question for you. Are you able to answer the question? Okay, for Jasmine, we still trying to connect that to Mr. Montero. Maybe we can wait a minute for response from Mr. Montero. Okay, I think there are some technical issue from Mr. Montero because he lost his signal there and causing him to not be able to join us and continue or answering this question. Maybe we can forward this question to Mr. Montero, and if he still have time in another time, he can answer the question and we will deliver to you. Let's continue this conference to the next agenda. Thank you for all the speakers and participants that come today for this conference. I will read the summary for this conference. The first session from Prof. Lorenzo presentation today mentioned about the development of the European Union Energy Law. There are 4 points of the development, and also Professor Lorenzo mentioned about 5 main waves of regulation at the European Union level. Also, Prof. Lorenzo had presented us about the Millennium Ecosystem Assessment Framework. There are ecosystem services as linked to human well-being, multi-level governance, drivers of ecosystem change. In the presentation of Prof. Lorenzo, also explaining about social ecological resilience, theory, sustainability and integration, hierarchical integration of 3 Ps is problem relating to conferral, principle of conferral or attribution, equity and participation, sustainability and adaptability, sustainability and secondary law. Also, the next session from Prof. Teknan, the key environmental status, there are Clean Water Act, Resource Conservation and Recovery Act, Safe Drinking Water Act, Comprehensive Environmental Response, Compensation and Liability Act, and the GREAT Special Act, National Environmental Protection Act, Toxic Substance Control Act, Federal Insecticide, Fungicide and Prudencide Act, Emergency Planning and Community Right to Know Act. Prof. Hillary also present us about regulatory authority, regulatory enforcement, a case of Chevron USA versus Natural Resources Defense Council, environmental permits, penalties, renewable energy, environmental insurance, environmental tax, US climate change policy. Also, for the next session from Dr. Dina, mention about climate change refers to long-term shift in temperature. Climate change gives us some effects such as effect on the biodiversity, effect on ocean, effect on human, effect on the weather, and also Dr. Dina has mentioned about Malaysian contribution to climate change itself. There is also the way forward and conclusion. Given the seriousness of the environmental issues and setback, the international parties together with Malaysia must work more efficiently to ensure the sustainability of the environment for our future generation. And next from Dr. Montero, dari 168 negara Timor Leste telah meratifikasi UNCLOS. Dr. Montero juga menyatakan bahwa hukum laut internasional yang ada di Timor Leste, berbagai konvensi dan juga peraturan yang sudah diratifikasi oleh Timor Leste, dan kerjasama yang dijalin antara Timor Leste dan Indonesia, dan berbagai permasalahan yang ada seperti illegal fishing, keterbatasan dana yang ada di Timor Leste, dan juga pengawasan yang lemah, kurang adanya peralatan yang menunjang, dan juga kurangnya SDM, dan juga seharusnya Timor Leste itu memperkuat fasilitas dan juga sumber daya manusia. So that's the summary for this conference. I'm Hannah Gracia as the moderator for today. I want to say thank you for all the speakers to come and present the material for today's conference. And thank you for all the participants because you guys already be active on this conference and asking your question to the speaker. I'm sorry if there is any mistake that I made alongside this conference, and for the next agenda will be delivered by the MC.
Thank you, Hannah, for such a brief session for the discussion and also the speakers for the insightful material for the climate change happening now and the regulations in the Europe, USA, Malaysia, and Timor-Leste. It was such a great and amazing knowledge for us related to our conference topic today. Ladies and gentlemen, those are the agendas we have presented to you this afternoon as we have finished our conference, ICEP 2022. Therefore, we are going to close this international conference. For all the participants, we remind you to fill the attendance list to get the participant certificate. The link to the attendance list has been given in the chat box by the committee. And before we leave this Zoom meeting, I would like to recall all of you, the speakers, and every participant to please open the camera, and we are going to take some pictures for documentation. Okay, everyone will wait several minutes to wait. Okay. Okay, I will count 3, 2, 1 for the first slide. Sorry, now for the second slide. And then the third slide. Okay, that's enough for the documentation. Thank you, operator. And once again, I would like to say thank you for the speaker today, Prof. Mr. Dr. Lorenzo Quintani from Faculty of Law, University of Groningen, Prof. Dr. Hillier Tegnan William from William and Mary Law School, Dr. Dina Imam Supat from Faculty of Sharia and Law, University Sains Islam Malaysia, and Dr. Sugito Monteiro SHMH from the Faculty of Law, Universidad Dili Timor-Leste. Thank you for the Excellency's guest, ICEP presenter, and all of the participants who are attending this conference. And see you to the next ICEP in 2022. Please attention to the presenter now of ICEP 2022. Coming up to the very last agenda, we are going to have a parallel session. Thus, for those who join the parallel session, please remain in this Zoom meeting because we will get important information related to the technical term during the parallel session later. My turn as Master of Ceremony is up, so for the committee, the screen and time are totally yours. Thank you and good day.
Thank you. Bye.
Thank you. Bye-bye, everybody.
Thank you,
Be safe.
Budina.
Mr. Tegnan.
Bye.
Thank
Prof,
you.
thank you everyone. Have a good day. Thank you for all the
And
speakers.
Dr. Seguito. Thank you. Assalamualaikum, selamat sore kepada peserta ICEP 2022. Bagi teman-teman, Bapak Ibu yang kemarin mengikuti conference, yang mengirimkan paper, mohon untuk tetap berada di Zoom meeting ini. Terima kasih.
Halo semuanya, selamat sore. Assalamualaikum warahmatullahi wabarakatuh. Orangnya enggak ada yang bawa dulu.
Assalamualaikum Bapak.
Waalaikumsalam warahmatullahi
Selamat
wabarakatuh.
sore, Bapak.
Sore, ini yang mengirim artikel semua ya? Atau dibuatkan sesi khusus saja nanti diundur Mbak Uli? Ya. Ya, mana dia? Willy. Mana? Belum hadir. Baik, teman-teman semua, hari ini rencananya saya mau memberikan catatan terhadap beberapa artikel yang untuk keluaran untuk prosding ICEP. Untuk prosding yang kemarin teman-teman kirim. Jadi prosding yang akan dituju rekan sekalian nanti ke prosding KNE. Prosding KNE ini juga terindeks di website atau Thomson Reuters. Untuk yang Atlantis, teman-teman sekalian, Atlantis tidak menerima 30 artikel. Minimal di Atlantis minimal 50 artikel. Jadi jika kita kirim ke Atlantis, tentu tidak memenuhi persyaratan yang ditentukan oleh Atlantis. Oleh sebab itu, nanti kemarin kami sudah menemukan prosding kembali untuk dikirim, artikel rekan-rekan sekalian untuk dikirim. Nanti kemana dikirimnya? Ke KNE Prosding. KNE Prosding ini juga ada di Turki ya teman-teman sekalian dan terindeks di Web of Science sesuai dengan ketentuan yang ada di peraturan rektor. Nah, untuk teknisnya sebenarnya saya pengen memberikan catatan hari ini, tapi ini melihat satu waktu yang sudah sangat sore, terus yang kedua banyak juga yang tidak hadir. Saya merasa rugi nanti memberikan setengah-setengah. Saya pengen memberikan langsung dari awal sampai akhir apa catatan dari artikel ini. Itu kira-kira teman-teman sekalian untuk info terbaru terkait artikel, tapi nanti akan saya berikan waktu lagi untuk rekan-rekan sekalian untuk kita diskusi. Nanti kita buka lagi ya teman-teman sekalian sekitar kalau tidak Sabtu malam ya Minggu malam. Ini lagi sekali Sabtu malam atau Minggu malam. Nanti kita buka forum diskusi untuk berdiskusi terkait dengan artikel. Ini saya lihat pemilik artikel belum hadir semuanya di sini. Ada yang mau ditanyakan terlebih dahulu dari teman-teman sekalian? Saya kira tidak ada. Kalau tidak ada, terima kasih. Sampai ketemu besok Sabtu malam atau Minggu malam. Saya informasikan untuk memberikan catatan terkait dengan beberapa catatan penting dari artikelnya. Baik, kalau tidak ada, terima kasih. Sampai berjumpa di waktu selanjutnya. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam warahmatullahi